Okay, we had a breakdown and took a short recess here in this hearing. We are back with the 124-343 hearing. We're going to continue our argument right where we left off. Mr. Clyde, you had just used your 15 minutes, so you'll still have your 5 minutes of rebuttal. Mr. May, we will now turn to you, and you may now proceed with your argument.
Thank you. May it please the court, Your Honor. Lerner does not challenge the district court's conclusion that it had subject matter jurisdiction. And that conclusion was necessarily reached because the court addressed the claim, I will call it, and concluded in exercising its discretion that the claim, I will call it, was better suited and heard in a Chapter 60 proceeding, which could have been instituted by Mr. Pippen in Miami County. Instead, it was instituted by Mr. Lerner in Johnson County. And it's clear that it was a discretionary call from the district court's perspective, because the order itself said that the court was exercising its discretion. And as Mr. Clyde noted, the court believed there should be discovery, there were potential experts, lots of factual testimony, and that a second trial was necessary. Importantly, this is a breach that should be, and Lerner's claim in Johnson County is a breach of contract claim. And that is the case whether Lerner, the attorney, is the plaintiff, or if Mr. Pippen elected to be the plaintiff. The argument that Rule 1.5e is in some fashion, quote, mandatory, would of course be completely inconsistent with the procedures available to and historically and today applied by a district court. For example, Mr. Pippen's argument in this case turns on that the district court is required to entertain a case brought before it, even when there's an available alternative forum, and even when there are procedural protections at issue that any party in litigation would be entitled to. Lerner does not contend, Your Honors, that he's not subject to regulation by the judiciary. He doesn't contend that he does not have certain obligations under the rules of professional conduct. He absolutely does. And that really has nothing to do with the current case before Your Honors. Another point which Your Honor alluded to is it's important to remember that this claim, and I don't want to use that as a term of art, but simply to describe what Mr. Pippen did, is it was dismissed without prejudice. So Mr. Pippen is trying to appeal an order dismissing a claim without prejudice. And importantly, and with all due respect to the court's initial one paragraph order on the motion to dismiss the appeal, the order does not comply with 6254B. In the case law, the court's clear, and we cited it, there has to be an express direction that judgment be entered. In this case, all that was determined was that there was no reason for delay for entering the judgment. There was never an express direction that one be entered, or was one ever expressly entered. So, and saying that it's a part of or only one claim really tells us nothing, because the applicability of 6254B is based on there being multiple claims and or multiple parties. The issue of the applicability of 1.5E, Your Honor, is, well, and I should note too, on the argument that the court is mandated under 1.5E to address in the procedural posture and form that Mr. Pippen advances, again, is inconsistent with any grant of subject matter jurisdiction, if you want to call it that. And plus, the language of the rule, it just authorizes the court to have the ability to address the issue. It's not mandatory.
Counsel, let me interrupt you with a question. You kind of were touching on this, but in order for us to even decide or get to the issue about whether the district court was required to make a ruling on the fees, we have to decide if we have appellate jurisdiction over this appeal. Now, I take it from the brief you wrote that you do not believe we have appellate jurisdiction here. And you just touched a little bit on 254B requirements. Do you have anything else to add on the appellate jurisdiction issue before you get back into the merits of the case?
I would again just emphasize, Your Honor, the nature of the order from which an appeal is sought, that is a dismissal without prejudice, and the jurisdictional basis being 254B, and that the requirements of 254B, in particular, an express direction that judgment be entered, are not met in this case. And for that reason, the court does not have the court does not have appellate jurisdiction.
You think just because the fact that the order was without prejudice, you think that matters?
I think that is a factor, Your Honor, that the court could consider, and courts have considered, including Kansas courts, Your Honor, given the inquiry on just reason for delay. And that could well be a factor that the court could consider in whether there's an appropriate 6254B, I'll call it, determination. That's
well, your brief certainly argued the fact that Lerner's not a party and there was no final decision. Those were I think, your two main reasons in your brief. You're not waiving those, are you?
No. And the answer clear, there was no final decision, but that's final decision in the 6258 sense. And because of that, the route that Mr. Pippen or the district court tried to take was to essentially make it an appealable final judgment under 254B. So no, there was no 6258 final judgment. The purpose of 254B is to take that situation, if you will, Your Honor, and based on two requirements in 254B, make that a final judgment for purposes of appeal. And 258 even references the 254B. So yes, we don't think there's a final judgment. With respect to the applicability of 1.5, Your Honors, it's clear that it's not Lerner's position that the rule applies only to contingent fee cases. Lerner's position is that there are portions of the rule that could only apply to contingent fee cases. And in fact, there are provisions of the rule that expressly provide they only apply to contingent fee cases. And we know, for example, that subsection B applies to rates of a fee or retention relationship, but those do not have to be in writing. But we also know that under subsection D, a contingent fee agreement contingent on the outcome of, quote, the matter must be in writing. So we know that subsection B can't apply to a contingent fee case, because if it was a contingent fee, it has to be in writing. So we know that D, which applies to contingent fee cases, says you can have a case, an agreement, a fee agreement, contingent on the outcome of, quote, the matter. Okay. Well, that term, the matter, Your Honors, I suggest is significant because it never appears in subsection B of the rule. And it only appears in subsection D, which deals with contingent fee cases. And it talks about upon conclusion of a contingent fee matter. Okay. And in that situation, you have to the lawyer has to inform the client of the right to have the fee reviewed under subsection E. Okay. Subsection B and no other subsection refers to subsection E. Okay. And subsection E refers to the appropriate court having jurisdiction of, quote, the matter. Well, an hourly fee engagement to handle a securities offering for Ford Motor Company is not intended and wouldn't be covered by these rules. That's not the matter and the outcome of the matter. And it talks about the appropriate court having jurisdiction of the matter. Well, in that securities offering, my example, it doesn't, the concept doesn't fit that there's jurisdiction over this securities offering matter that a corporate counsel is handling for Ford Motor Company. And that illustrates why 1.5E was only intended to apply to contingent fee cases. And the legislative history is clear on that. Granted, if there's some lack of clarity or unclear, some ambiguity in the overall meaning and application to the various provisions of 1.5, the legislative history makes clear that 1.5E was spawned by a concern and a direction to review and address contingent fees. And there was a committee created, and that committee came up with subsection E. That was not part of the model rules that were adopted in 1989. Okay. Those were added, if you will, by the committee. And the legislative history clearly establishes that. As Your Honor has noted, I'm sorry. As Your Honor has noted, every case on which Mr. Pippen relies concerns a contingent fee agreement. And again, that's consistent with the history. If the rule were construed as Mr. Pippen proposes, then namely being that it can only apply on a case in litigation, okay? Because that's the court that Mr. Pippen is telling Your Honors that this matter has to be resolved in, and it has to be resolved under 1.5E. Well, if that's true, okay, then there are constitutional issues of equal protection raised because similarly situated attorneys are being treated differently. This is not an issue. This is not a challenge to the court's ability to regulate attorneys and the law practice. But what Mr. Pippen's construct leaves us with is if you have a contingent fee and you file litigation, then you're compelled, if the client wants, to go before that same judge, and without the procedural protections afforded to other litigants in breach of contract cases, okay, without those procedural protections, and the court decides it. That court decides it, versus if you have a matter, a car wreck, for example, and you settle it before litigation, okay, well, then there's no court appropriate court with subject jurisdiction over, quote, the matter. So that lawyer doesn't have to go under 1.5E. Or if it's an hourly, my securities offering example again, well, that matter's not going to be in court. So there's a distinction made between attorneys, and there's no rational basis for it. And it actually impacts adversely, in this case, learners' procedural protections and due process protections that are afforded to litigants in court.
I'm sorry, counsel. I don't know how close you are. I don't want to make him go over.
You still have 4 minutes.
I want to clarify. You started off by saying you don't challenge that the district court had subject matter jurisdiction here. And now we're on to some due process issues. Are you under the impression that the district court has made a decision that is appealable to us with regard to the due process of your client?
The district court has not determined or conclude, well, the district court did not directly conclude and determine how in a proceeding before it, what procedural protections, if any, and if you accept Mr. Pippen's position, it would be, I guess, affidavits and time records. Again, and this is not a fee award case. This is not a fee award case. So the court did not directly address that, but I think indirectly, the court concluded that the learner should be afforded the procedural protections that a litigant is afforded under Chapter 60 proceeding. The court did determine that. The court didn't determine precisely what procedures should be available under 1.5E if the court heard the matter. And if the court under 1.5E is going to hear the matter, it is certainly learner's position that the panoply, if you will, of procedural protections, and you get to know what the allegations are, and there's some specificity required. There's discovery about whether a client has an agreement or an understanding or is promised to pay, a term different from the fee agreement itself. And of course, determining 1.5E, if you look at it carefully, Your Honors, there's a two-step process. And the first step is the court reviews just the fee agreement. Okay, reviews the fee agreement. If the fee agreement is unreasonable, the court then can set a reasonable fee. Well, certainly just reviewing the fee agreement doesn't tell one, for example, if activity A, B, C, and D were undertaken, and while undertaken in good faith and perhaps not reasonable to the result in the context of the fee award litigation, if the client directed the lawyer to take the action, that presents a different set of circumstances, and I submit a different conclusion on whether the attorney should be paid for that under the fee contract.
You have about you have about 1 minute, counsel.
Thank you, Your Honor. Your Honor, did I answer your question? I'm sorry.
I think it's fine. Thank you.
Thank you. And finally, with respect to the discovery issue, again, the district court hasn't determined what discovery, what procedures, if any, are available. The court, for that reason, has not expressly addressed these issues. I should note the court's well established for, you can argue different theories to support the right result for the wrong reason. We don't raise any issues. We're not a cross appellant. Because why? Because we weren't harmed. Learner got the relief he sought. What would he cross appeal from? There's no decision from which he could cross appeal. And so for that reason, the waiver arguments, and they're all present questions of law. The constitutional issues, Your Honor, if this court does not address them, then certainly if it went back under 1.5E, the district court judge would have to address those. Just like if it went back before Judge Montgomery, I would anticipate that Lerner would seek a stay of the proceedings in front of Judge Montgomery in favor of the pending Chapter 60 case in front of Judge Vano in Johnson County. And Judge Montgomery at that point in time, I would think Mr. Pippen may well agree if it's mandatory to proceed, but I would expect he would reach much the same conclusion he reached originally, which is the case is better in a Chapter 60 proceeding, and he would stay this 1.5E proceeding until that's resolved, and then rely on the result in that proceeding. That's all I have, Your Honors, unless you have any other questions.
Apparently not, counsel. Thank you. Mr.
Thank you.
Clyde, we'll turn back to you. You still have your 5 minutes of rebuttal.
Thank you, Your Honor. I'm going to start sort of where Mr. May left off. I think there's clearly an inappropriate reading of Rule 1.5 and all of its subsections. First of all, the court, when it's looking at a fee, doesn't just look at the fee agreement, whether it's verbal, written, contingent. There's 8 factors listed under Rule 1.5A that the court is supposed to consider in determining whether a fee is reasonable. Under Kansas law as it exists, I clearly think that we know 2 things. Number one, that all fee agreements must be reasonable. And the rule clearly says all fee agreements are subject to review. So there's no separation of any classes of attorneys who are subject to that. In a contingent fee case, if a contingent fee case that doesn't get litigated, it's subject to review too. Mr. May misunderstands the rule. It very clearly requires my contingent fee agreements, for example, being in Johnson County, always advise the client upon conclusion, whether it's been litigated or not, that the client has the right to seek review of our fees and expenses for reasonableness in the District Court of Johnson County, Kansas. That must be in the fee agreement. It's part of the rule. And whether it's litigated or not doesn't make any difference. And I would propose the same would be true of the general counsel or whoever's handling the securities matter for Ford Motor Company. If their office is in Johnson County and Ford Motor Company wants their fees reviewed, I think they have a right to go to the District Court of Johnson County and have it reviewed. I think that's what the rule says. The legislative history is also not as indicated. The legislative history referred to and included in the appellee's brief never included a review of Rule 1.5E as it was actually adopted. In fact, that was not part of the ABA model rules. Despite my rigorous search, I couldn't find exactly how and when Rule 1.5E was drafted. But I do know that in that history that was provided, specifically the committee asked then disciplinary administrator Arnold Winshuffle about contingent fee cases. And he indicated that his 10 years as disciplinary administrator, he had had very, very few complaints about contingent fee cases. The majority of complaints were about fees in divorce cases. So there's absolutely nothing in the legislative history to indicate that Rule 1.5E has anything to do with only contingent, that it's only subject to contingent fee cases.
Mr. Clyde, let me interrupt you with just a final question, and it's probably not a good question, but I'm going to ask you anyway. Everything's all teed up and ready to go in this Johnson County lawsuit to resolve the issues between you and Mr. Lerner. Why is it so important to you, for lack of a better word, for us to try to force the divorce judge to resolve this issue?
Well, I kind of answer that starting out with the same question. Is it was all teed up in front of Judge Montgomery. And basically our position is Judge Montgomery, having adjudicated and supervised the divorce proceedings, knows better than anybody what counsel did to earn his fees in those cases. And we know that he reviewed it once and he said he was charging more than a customary hourly fee. He knew that he didn't present certain valuation evidence that he thought he should have. He indicated that he wasn't as familiar as other attorneys in his court with divorce procedure and law. And so there's just all kinds of factors that Judge Montgomery already had in front of him that we felt made him the most qualified expert. And district courts are experts. That's been held many times to make that determination.
It sounds to me like you just really want to stick with that judge.
Well, I think that's where it should have been to begin with. I don't think we should have ever been taken anywhere else. Like I say, he's the one that's familiar with the proceedings. So I'm running out of time. So let me just on a final note say that on the jurisdictional issue, I confess that this was a unique situation. I took a belt and suspenders approach, and Judge Montgomery actually made this certified this as an interlocutory appeal. This court did not accept it that way originally, so we turned to the 254 certification and went that way. I guess the question is, I haven't found anything. I still believe it's a final decision, either that or it's a collateral appealable order. In any event, I haven't found any reason this court, if it wants jurisdiction, can't use one of those 4 avenues. Either go back to, just because it denied it the first time, does it not have jurisdiction to maintain an interlocutory appeal at this point? And if not, then is it not a final order or a final collateral order? So I think there's many respects here by which the court can maintain its jurisdiction to make what I think is a very, very important decision. I mean, this rule's been around for over 30 years. It's amazing that this hasn't come up before. And I think clients and the district court and attorneys need guidance on the issue.
All right, counsel, thank you both very much for your briefs and your arguments today. Sorry we had the technical difficulties, but we did make it through this. We'll take the case under advisement, get an opinion out to you and your clients just as soon as we possibly can. Thank you.
Thank you.
Thank you, Your Honors. And I apologize for the glitch, the transmission glitch.
No problem. Thank you, counsel.
Thank you.